Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So I've been sick and I'm still not 100%, but there's something I really wanted to talk to you about because it's got me really mad. And that is that the Law Society Tribunal out in Ontario has decided that a child molester should be able to practice law. And I have some thoughts and some concerns. So let's talk about those. Now, this individual is only known as AA, at least in public right now, because there's an order protecting his name. And that's not to protect him. A lot of people have expressed concern about that. But we can see from the original decision here, I've concluded that an order should be made that the name of the applicant be anonymized in the title of proceedings, and that any decision, orders, or other documents made public in this proceeding should refer to the applicant as AA, his ex-spouse BB, and his children solely by initials. I have also concluded that an order should be made imposing a publication ban with respect to identifying information relating to the applicant, his ex-spouse, and his children, including but not limited to their names, dates of birth, ages, genders, and addresses. So this is something to keep in mind as we go, is that this order was put in place not to help him, but because there's victims involved. So let's look at what went down. So at the time of the hearing, the applicant was 40 years old. While an adolescent, he experienced a religious awakening and became strictly religiously observant. He married at a young age and traveled with his young family to engage in religious studies in another country. His goal at that time was to become a religious leader and eventually lead a congregation. His faith and religious studies played a central role in his life during that period of time. It was also then that he found himself experiencing symptoms of sexual dysfunction that concerned him, and also concern us. He viewed pornography and engaged in surreptitious masturbation in public settings. That's not good. The applicant sought guidance from religious leaders and some therapeutic counseling with limited success. It is undisputed that in 2009, during a 2-month period on 3 occasions, he engaged in acts of sexual abuse of minor children, including one of his children, that involved touching them and being touched by them while clothed. I don't know that I can say that this reconciles at all with his notion of being strictly religiously observant, because I don't know of a religion that says this is cool. Yeah. His conduct came to light when the father of one of the children confronted him. The applicant spoke with a religious leader and a social worker and disclosed what had happened to them, his then wife, and the local child protection agency. He was not criminally charged, began to take medication to curb his sexual dysfunction, and was subject to supervision when around children, including his own, for a few months. The applicant concluded he could not continue on his chosen path of becoming a spiritual leader in his community, given his actions. But lawyer apparently is fine. He abandoned his religious studies, and the family returned to this country. While he continued to seek therapeutic treatment upon his return in 2009, he was not initially open with his medical practitioners about the nature and extent of his past actions or his condition, and instead disclosed other, lesser issues. He did speak to the leader of his congregation, whom he trusted, and made what he called a vague disclosure that he was involved in incidents involving the sexual abuse of children. Although he did not contact the local child protection agency in his new community, it received a referral in 2010 from an anonymous source with regards to his prior sexual abuse of children. He acknowledges that, in his discussions with the agency, he minimized the nature and extent of what had happened by describing it as one incident rather than 3. The Child Protection Agency became involved with the family. You can see that he's not being honest as this goes, right? They monitored and visited them actively for a year and recommended continuing supervision by trusted family members when the applicant was in the presence of minors, a recommendation that he's not requested be lifted and that remains in place more than a decade later. Having decided against continuing his religious studies, the applicant then attended and completed his legal education. He found himself in an environment where, for the first time, he was not surrounded by co-religionists. His focus became more secular in nature, and his family followed suit, with the children moving from parochial schools into the public system. In his first application to be licensed as a lawyer in 2012, the applicant did not initially disclose any of the events of 2009. An anonymous letter prompted the Law Society to launch an investigation. During that investigation, he continued to withhold medical records and information about his serious sexual misconduct. So, when he didn't tell anybody, and when they found out, he lied and hid things and was deceptive and duplicitous. That really doesn't suggest somebody who's going to be a great candidate for being a lawyer. The applicant admits that until 2017, when he discontinued his first licensing application and agreed to pay the costs incurred by the Law Society related to his license application, he was not truthful with a number of people. Prior to the May 2014 investigation, he had minimized his actions in discussions with medical practitioners, and from that date until he withdrew his application, he admits that he also did so with the Law Society. By failing to own or acknowledge everything that he had done, he admits that he behaved dishonestly. I mean, that seems fairly obvious. He rationalized and tried to justify his actions, describing himself as scrambling to avoid the shame that he imagined that he could not survive in a world where he was outed as a child sex offender. Okay. Now, I could see the argument for rehabilitation and so forth, but not in a situation where you're dealing with somebody who repeatedly lied about it and repeatedly caused issues in that sense. Notwithstanding that, the tribunal initially said, okay, we're going to grant, we're going to let this guy be a lawyer. And the Law Society of Ontario appealed this because they were not happy with that at all, and they don't want this guy to be a lawyer. And I agree with them. So they got a stay of proceedings, and they raised a number of concerns in order to get this stay. And a stay of proceedings basically means that while they were appealing this, that he wasn't allowed to become a lawyer. So let's look a little bit at that decision because it provides some really interesting insight into what's going on here and a little bit more reason to be concerned. As I said, I got some concerns. So let's have a look at that. So the good character hearing involved an analysis of whether AA, who engaged in the sexual abuse of children in 2009, including his own child, and who was dishonest about that sexual abuse with the Law Society and others for many years, was currently of good character. Now, you remember how I noted that that publication ban? The reason why it's there is to protect his child who was a victim. So if his name is revealed, it ends up revealing the name of that child. That's going to be a concern as we go. Just remember that for later, because there's going to be some issues with that. AA first applied to be licensed as a lawyer in 2012, but did not disclose the sexual abuse. A week or so prior to his call to the bar in 2014, so he was all set to become a lawyer. It was ready to happen. An anonymous letter revealing child sexual abuse committed by AA prompted the Law Society to launch an investigation into his good character and put a halt to his call to the bar. Do you think it might have been, I mean, maybe it was his ex, maybe it's one of the victims? Somebody out there doesn't want him hiding this. And good, because if they hadn't sent that letter, he would have hidden this and nobody would have known. During that investigation, the hearing panel noted that AA continued to withhold medical records and information about his serious sexual misconduct, and that's from the licensing reasons. In 2017, AA discontinued his licensing application. Following that discontinuance, AA engaged in steps, as described by the hearing panel, to try to atone for his actions. He reapplied to be licensed as a lawyer, and in January 2019, the Law Society commenced a second good character investigation. The good character hearing took place in August and September 2022, concluding in September 12, 2022, and it released its reasons finding AA was of good character, which is insane, but let's continue. So the Law Society, in the notice of appeal, alleges that the hearing panel, 1, misapprehended evidence in a manner that impacted its analysis of whether the respondent was of good character, 2, failed to consider relevant factors. 3, erred in its determination AA was of good character. 4, failed to place sufficient weight on the importance of maintaining public confidence in the legal professions. Because, I mean, I'm a member of the public, although I'm also a lawyer. This shakes my confidence in the legal profession, and I'm just going to guess from the comments that are going to be coming that I'm going to guess a lot of you will have similar feelings about that. Misdirected itself when making a finding AA was of good character, while at the same time imposing a restriction on his ability to meet unsupervised with minor children. So what happened there is they said he's of good character, he can become a lawyer, but he can't meet with children alone. And I find this to be a little bit concerning because, I don't know, like if let's say we take a piece of paper here and, I'm just going to, we've got our sheet of paper and I'm going to draw a Venn diagram on it. So here we'll put a little circle, and this is going to be real rough because I'm drawing it in the air. That'll be our circle for of good character. And then we can draw another circle for not able to be in a room alone with children, except that I can't put that circle here. I'd have to actually draw it in deep space where they should have thrown his application. This is like, oh, he's of good character, but you can't leave him alone with kids because he might touch them. What? No. Okay, so we're going to skip over the test for a stay because that stay has already expired because the appeals happened. But we're going to look at some of the reasons that were presented. So in consideration of rehabilitation, while the hearing panel referred to the evidence of the psychiatrist who assessed AA in 2021, it did not refer to the psychiatrist's evidence that AA continues to endorse 4 of 38 statements endorsed by known child molesters. The psychiatrist acknowledged that while not clinically significant of themselves, the answers represent that AA has not changed completely his thinking when it comes to children, despite treatment AA had received up to the date of the assessment in 2021. The psychiatrist agreed that AA's endorsement of the 4 statements also demonstrated AA continues to have some problem with insight. Now, these would be statements that people who abuse children tend to agree with, and people who don't abuse children tend not to agree with. So it's concerning. These are, I don't even want to give examples because YouTube would probably throw me off the platform. These kinds of statements are kind of creepy things. So the psychiatrist agreed that AA's endorsement of the 4 statements also demonstrated AA continues to have some problem with insight. AA also endorsed 6 of 36 statements endorsed by known rapists, which to address would require him to deal with gaining insights on holding these views of women. While in the review of the psychiatrist's evidence, the hearing panel referred to AA being wise not to engage in activities that would bring him into contact with women or children unchaperoned so that no questions arise. So, he's of good character, but we can't trust him alone with children or women. It did not address the statements that AA continues to endorse about children or women or their impact on rehabilitation. The hearing panel also relied heavily on AA's evidence and his self-assessments, but did not address or reconcile those findings with the evidence of the psychiatrist relating to potential self-deception by AA. Self-deception relates to how good AA is at convincing himself that what he says is true. An example is that the hearing panel found that the psychiatrist diagnosed the applicant as suffering from a pedophilic disorder in remission, but it did not address the psychiatrist's evidence that both the diagnosis and the finding that was in remission rely on AA's self-assessment that he does not have pedophilia or an sexual interest in children. On those issues, the psychiatrist was unable to determine if AA was telling the truth, convinced himself he was telling the truth, or was lying. So we don't actually know if he's better at all. He could be lying. And that's concerning because we're dealing with an individual who has lied repeatedly in his quest to become a lawyer. So, is there a real possibility that he's lying? You betcha. That is exceedingly worrying. Second, the psychiatrist, during evidence, raised the issue of AA being wise not to engage in activities that would bring him into intimate contact with children or women unless he'd taken precautions such as a chaperone. The hearing panel imposed the condition that AA not meet with minor children while unsupervised without further submissions. The finding that AA is of good character, but that he's subject to a condition not to meet minor children while unsupervised is a ground of appeal. The Law Society questions whether the condition is internally inconsistent with the order and raises issues about enforceability, particularly in the face of an anonymization order which prevents publication of AA's name. How can we keep him away from children if we can't tell people about him? Anonymization also raises the issue of how the public would know of the restriction on AA's license. This raises a serious issue about the internal consistency of the licensing order and restriction. And I would also say that the internal consistency is threatened by the simple fact that it is absolutely ludicrous to say somebody is of good character, but they can't be trusted around children or women. But women, they kind of leave that out. They apparently, that's not a concern. So, thanks, Law Society. I'm sure there's some women out there who are really feeling protected by you right now when there's a recommendation that he not be alone with women, and you're like, kids is fine. So, that stay was imposed. That stay basically prevented him from becoming a lawyer up until his appeal. And that appeal has happened, and the appeal has said, sure, he's of good character. He can practice. But they had one further restriction or one further thing that they were going to add. And they note here that one of the concerns was the whole issue of, will he, how do they present, like, how do they publish his name? Now, the Toronto Star, who's reported on this, and I'll link them below so you can check out their article, notes that if the court declines to grant a stay, AA will be entitled to be called to the bar. Should that happen, the condition that he not be alone with children will be included with his name on the Law Society's public registry of lawyers, thereby identifying him. And the panel states, this will obviously create difficulty for the respondent on both a personal and professional level, but in this appeal, he is explicitly recognized and is prepared to deal with this. He accepts, and we do as well, that the publication of the tribunal order will further protect the public interest. So he's saying, it's okay, I'll live with the consequences of having my name out there. But the publication ban was never to protect him. That was never the point. The point was to protect one of the victims, his child, whose name would be revealed by this. So I have some concerns about him saying, oh, don't worry, I'm fine with you revealing the name indirectly of one of my victims and subjecting them to possible, like, people are jerks. And if people find out that somebody was abused as a kid, they may be a jerk to that person about that. So, yeah, I've got some serious concerns, and the Law Society is appealing this. They are seeking to challenge this. They want a further appeal, and they want a stay of proceedings. And quite frankly, I hope they succeed, because I do criminal defense, which sometimes means doing, criminal defense of young people. Kids get charged with things, right? Kid throws a rock through somebody's window, they get charged. It happens. Or kid gets into a fight at school. These kinds of things, right? And people need to have confidence that the lawyer can meet with the kid, because that's often required. I'll often have to meet with somebody and talk to them without their parents there because a whole lot of reasons. If their parents are there, the kid may not be honest, but also it might breach privilege. There's all sorts of serious issues. And so the public needs to trust lawyers. And they can't do that if the regulators, which includes the tribunal here, are not protecting the public from people like this. I could see the argument about rehabilitation if it wasn't for the fact that this is somebody who has a known history now of concealing things and deceiving the regulators. Once that happens, how do you trust them ever? I'm all for rehabilitation, but I don't see this as a situation where we should take that shot. There's certain professions that you might want to be a little more careful of. You know, I don't think this guy should be a teacher. I don't think he should be a lawyer. I don't think he should be a police officer. I don't think he should be a doctor. I don't think, you know, any of these positions of high trust, not so much. Now, one of the other things I'm going to just note here as part of my concern is that one of the things they identified is that he has actually been working at his father's law firm, and they say that he has handled some thousands of files in the meantime. And so that to me doesn't say that this guy is super trustworthy. It says, hey, I have some concerns about his dad and whether that was good judgment and whether that continues to be good judgment and protection of the public. But I guess if this decision goes through, we'll find out who he is and probably who his dad is. And people may have thoughts. Just, I wonder if this guy's thought this one through. Anyway, those are my thoughts. As I said, I'm pretty pissed. I don't think this is okay. I don't think this is appropriate. And I don't understand. I've read their reasons on the past decisions. I've read the quotations from the reasons. The full reasons will be coming out. I guess I'll review those when they do, but I don't get it. And normally when I read a court decision, I can go through and be like, okay, I follow the reasoning. This makes sense. Their reasoning makes no sense to me. It just doesn't. So anyway, let me know what you think in the comments below, but be civil. No calls to violence, no anything like that. But you know, you can be upset. Just be upset reasonably. Like, yeah, don't do anything to get me in trouble here, guys. So thank you for watching. I hope you found this to be interesting or educational or horrifying, I guess. I'm not sure what else to say. Please like this video, subscribe to see more of my content, and yeah, I'd also like to thank my Patreon supporters at the $50 level: Purple Dragonair, CCFR, Canada's National Firearms Association, and the Canadian Shooting Sports Association. And at the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.